First, even though we all kind of know who you are, if you can perhaps give us 60 seconds or so, just a quick intro as to who you are and why you're running for this particular seat, and we'll start with Maria.
I'm Maria Maskall. I'm running for Family Court Judge in Department T. I've been an attorney now for 21 years, or wait a minute, I'm sorry, 24 years. I obtained the New York State Bar in 1990, Washington, D.C. in 91, and then I moved here in 1997 and got the Nevada State Bar in 1997. I have been practicing primarily family law since arriving in Las Vegas. I practiced primarily criminal law in Washington, D.C. I still sit on the North Las Vegas Justice Court bench as a justice pro tempora on occasion, and I've been doing that since 2007. I enjoy being on the bench. I have won plenty of awards, numerous awards with the Pro Bono Project, including Attorney of the Year in 2010, and now I want to take my community service and bring it to the bench. That's why I'm running for judge.
Thank you. Gayle?
Thanks, John. I have when I was elected in 2010 by 15 percentage points. I think the voters like the fact that I've been practicing law for 22 years, 17 of those primarily in family law. At that point, I had tried about 1,000 cases and had thousands of clients in the family court. I've also been an appellate attorney, as you know, John, in my practice. I've taken about 16 cases up to the Nevada Supreme Court and argued en banc before the Supreme Court as well as before 3-judge panels. I've also been up to the Ninth Circuit Court of Appeals on a case as well. I think what the voters really liked as well was that I have a master's in special education, and so I understand child development, and that really comes in handy in the family court. I've also taught family law at UNLV's paralegal program. I've taught family law to the Southern Nevada mediators and to other entities around the valley, and I think that the voters appreciated that as well in 2010, and I think that that will resound with them again in 2014.
Thanks, Gayle. Obviously, Gayle's our incumbent. I wanted to mention that. Lisa.
Okay, my name is Lisa Brown, and I'm running for Family Court in Department T, as we all know. I was a family court judge from 2001 through 2008, so I have 8 years of judicial experience, and I also have years of experience just as a family law practitioner. Right now, I'm in family court probably a few times a week. I have a contract with the county. I represent parents who are in the foster care system who have their children removed. So I'm in court quite a bit on a regular basis. My litigation skills are still there. I also represent children who are in the foster care system pro bono. That's my volunteer work through the Children's Attorneys Project. I've also served as guardian ad litem for some of the children in family court. Some of the judges have asked me to do that. Personally, I became a foster parent 16 years ago, and that decision changed my life. I adopted my son Zachary, who's 15 now, and 8 years after, when Zachary was 8 years old, I was very fortunate to get a phone call that his brother, his biological brother, was in foster care up in Reno. So he came with us when he was 2, and I adopted him. So I have 2 special needs children. I think that gives me a lot of insight into some of the issues that come before us in family court. And I'm very proactive as far as protecting children and helping families. That's what I do personally and professionally, and that's why I'm running again.
Okay. We'll start this next court with you, Lisa,
Sure.
and then go back around the panel. You know, you have all three of you have very good perspectives on both sides of the bench with respect to how family court works and the intricacies that it requires. What do you see as the biggest inefficiency in family court? And if you're re-elected to the bench, how are you going to address that?
I think that there should be more of a consensus on how to treat certain things. And just for an example, things that are submitted for decision, say an uncontested divorce. Something as simple as that, you still have the departments having different requirements for things such as service. So I think that the judges need to come together and make a uniform standard for all of that, and that there needs to be more harmony so everyone treats everything the same, so the litigants know what to expect. They really shouldn't have to say, hey, what department am I in? Okay, in that department, they want you to do X, Y, and Z. But if you're in this department, you can do it this way. I mean, and you know this, John. I mean, it depends. And these are simple things. I mean, we're talking about uncontested divorces, we're talking about name changes, you're talking about service. I just think we need to come together and have more uniform standards so that the litigants know what to expect.
Okay. Gayle.
Thank you, John. When I took the bench and as a practitioner, one of the biggest issues I saw was people coming back time and time and time again to court because the judge wasn't ready or the litigant wasn't ready. They didn't bring in all the papers that they needed. And 61% of our litigants are proper person litigants. They're not represented by attorneys. And so one of the very first things I did was I set up an information sheet in English and Spanish. And it tells the litigant what they need to do for their next court appearance, if there is another court appearance, or what they need to do to finish off their case. And I find that we have a very high compliancy rate with what needs to be done to finish up the case, because we're telling them on a big sheet of paper, not just a little sticky that gets handed to them, what needs to be done. And we have judges meetings every month, and we have bench bar meetings every month. And I've told the lawyers this a number of times, that they have one of the most receptive judiciaries I've ever encountered. And I was admitted in New York, and I practiced in New York for 5 years. And it sure wasn't like that in New York, and I've wandered into California courts a couple of times as well. Our judiciary, our bench, is very receptive to the lawyers and the issues that the lawyers bring to us. And when they bring them to us, we talk about them at the judges' meeting, and we try to make a resolution. And so when they have some issue, and it's brought to our attention, we look at it and we see, is there any way for us to, to resolve it? Is it a clerk issue? Is it a department by department issue? We have an independent judiciary, and so each judge looks at things in different ways. And as far as efficiency in the courts is concerned, I, as well as the other judges, really do work in those judges' meetings and afterwards at making the court run smoothly. And it is a group effort there. Bringing all the different components of the court together. The FMC, how can that run more smoothly? How can the clerk's office run more smoothly? And I have to say that the different parts of the court, I see it as a lot of moving parts, our courthouse, and they are very receptive to suggestions and solutions to problems that come up. I know that they are receptive to me.
And I'm sorry, Maria, before you answer, I've been making this disclosure and I've forgotten it for everybody today, and I'll remember it at the last second now. I have one case that's currently pending in front of Judge Nathan. However, it's going to be a summary dispo. It hasn't even hit your radar. You probably have no idea.
I have no idea.
It was just recently filed within the. It's a quickie divorce for a friend of a friend. I'm stupid for taking a family law case. I'm happy that's on the record. But I'm sure it's going to come back and bite me.
My question: when did you start doing
It's
family?
just when I forgot about what it was like to do family law. That's when I started taking them again. That's why I don't anymore. But I just for your collective edification, I have one case. It's not. There's going to be nothing substantive. I honestly don't even know. I don't think I've ever appeared in front of you on a substantive matter.
No, it was, you appeared once and that was it, so it couldn't have been.
I might have had a cup of coffee for somebody else, but I've appeared before Judge Brown numerous times because I was in
years
the trenches,
ago.
In the trenches all the time back then. But just for your edification, for purposes of the endorsement committee and full disclosure, I got nothing going on in this department. So
Thank you for telling us.
So that having been said, I'm sorry for derailing things. Maria, on to you. Biggest inefficiency in family court, and what would you do to remedy it?
Time. I think, well, first let me just begin. I think that what Lisa said was absolutely accurate. When I first moved here in 1997, I could actually tell a litigant, look, here are the facts of your case. This is the law. This is going to be the outcome. Because pretty much every single department was right on track with every other department. That was when the departments went A through, I think it was H at that time. Now we've got A through T, and it's until a complaint has been filed and until you know exactly which department you're in, you have no idea what the outcome's going to be. And you can't tell a litigant with any amount of certainty that here are the facts of your case, this is the law, this is the most likely outcome. Because it truly does matter which judge they are before now, where that never was the case before. So I do echo her sentiments there, but not just with the summary dispositions and everything. I think for pretty much everything, having some kind of uniform deal, and obviously judges have personalities, and those are things that the attorneys need to play to, the litigants need to know about, and all of that. But I do believe that it's not as uniform as it once was. It's not as cohesive as it once was. I would like to, and I'm not sure. It's great looking forward, trying to think that I can change a system. But since so many people have gone before me, I'm hesitant to think that I'm going to be the one who can change everything. But then I want to get back to time. I think that probably one of the worst things for my clients is they're paying anywhere from $200 to $450 an hour for an attorney to sit in family court. And sometimes if their case is at 9 o'clock in the morning, they may not be heard until 12, 12:30. 1 o'clock in the afternoon, they might not get up before the bench until 5. I think that can be remedied by staggering cases, and it depends on which courtroom you're in as to whether or not you're going to be there for the 4-hour period or the 3-hour period. But I do think that that's something that each judge and each judicial department has to pay close attention to, because it does get infuriating for a client to come before a judge after waiting for so long, knowing that they're paying their attorney hundreds of dollars just to sit. So that's one thing that I would change. Of course, the unified approach to the bench. I'm not sure exactly how you get 20 judges all on the same page, but I think that is something. I think that is something that has to be discussed, and it's something that has to.
I'm sorry, I'm not sure. It's a stupid question.
Mm-hmm.
Isn't clerk the one that handles the calendar?
Well, the clerk. It's not the clerk that actually sets the calendar. It is the court clerk who sets the calendar. But the judge still has control of their calendar.
So which means the clerks are not too qualified, or they're not trained the same.
No, because judges can say, look, I don't want a staggered calendar. I want someone at 9 o'clock, 9:15, 9:30, 9:45, rather than scheduling 12 cases at 9, and whoever shows up first goes first, and the rest of them just kind of wait.
May I
That's
answer that? May I answer
Sure.
that? And I don't know if it's changed over the past 6 years, but I can tell you when I was there, the judge is in charge of their calendar. You sit down and you see which days you're in court, and you decide what you want to do. Normally, the norm is in the mornings you'll hear motions. They set probably 4 to 5 an hour. That's been the norm. And then in the afternoons, they'll do trials. Now, not every judge does that. Some judges like to do all their motions on one day and just have everybody there. But it's completely up to the judge. What they do is they say, here's what I want on these hours. And then the clerk's office will schedule it. So it is up to the individual judge what their calendar will look like.
And Gayle, is it the same or similar process?
Right. We have what we call session sheets, and we can change our calendar at any time. It takes a little bit time for the new sessions to roll into, but every judge already has a staggered calendar. We set up our mornings and have some judges have more detailed calendars than others. TPOs, return motions, motions on for the first time. There's a whole list of ways they can categorize their docket. But all of the judges have a staggered calendar to hear so many matters during the day. For instance, I sit down on a regular basis with my clerk and my JEA, my judicial assistant, and we go through the calendar to make sure it's working, to make sure that we're not getting jammed up, that there's not too many cases for me to prepare and hear. I set 4 trials every week 4 trials every week. That's a very vigorous schedule, but I do that. A lot of them settle, fortunately, so I don't have to be hearing 4 a week, but I do set that many a week. I think it's important to keep that kind of motion going because...
All right.
We good? Oh, okay. And Maria, you were following up on the RJ's judicial performance evaluations, and it's not necessarily anonymous.
Number one, I don't think it's necessarily anonymous. Number two, I think that attorneys, you send them out to a bunch of attorneys. Some don't practice family law at all, and yet they may say, oh, you know, so-and-so is a friend of mine, so I'm going to answer all good stuff for her, and this other judge didn't do something that I like, so I'm going to give them bad marks. And I think that it falls on the attorneys to really be diligent in how they respond. And it's very difficult when you've been upset by something that a judge has done not to say something bad about them, or at least that appears to be what a lot of people have done. I also think that if they could somehow encourage everybody to report and to fill out a form, everybody who's had at least, I don't know, 1 or 2 appearances before each of the judges. But again, that takes away the anonymity. If you're targeting individuals saying, look, we know that you've been in family court and you've appeared before every single family court judge here, we want you to fill out the form, it takes away the anonymity entirely. So I'm not entirely sure how I would improve on it. I just think that, because I think that the questions are good. I absolutely think that the questions are good. The fact that they have a comment section is great. I just think that a greater participation should be encouraged, and probably
a tracking number.
well, they have it. You see, they have it. They have a tracking number, and I know in my own firm, we didn't get none of us received any of the surveys this year. So no one in my firm received the surveys.
A couple people have said that today.
Yes.
Right. So one of the partners of the firm asked if I knew where the surveys were. I called somebody who told me, I don't know, I tracked down where the surveys were. So they emailed them all to us, but all of them came with tracking numbers. And of course, once they showed up, a lot of the attorneys in my firm were like, this isn't anonymous. I'm not filling this out if the judge could figure out that I filled out that form. And so there you go. But it appears as though the people who are most reluctant to fill out the form are the people who have negative things to say about the judges because they don't want the judges to find out.
How long is the form?
You know, it's not very long. It's maybe 1 page.
So the judge should pass out. Here's the
Because
card.
it's
Here's the tracking number.
I'll be honest, I filled it out last year, and I filled out maybe like 2 family court judges and 20-ish district court judges and another dozen JPs. It took me about an hour. It's about 2 minutes per. Yeah, it's about 2 minutes per judge because they ask you maybe 10 questions per judge. So maybe a minute per judge.
I only need the family court judges.
Yeah.
That should come from the top. You know?
It's like
But
maybe
it's
a half an
the court
hour.
system.
Yeah, it's not.
Give the judge, everybody pass out a card. You got to fill it out before you go out the door. And they drop
Like
it in
a
the box.
survey.
They drop it in the box. They drop it in the box.
They
So
could do
it's-
that.
What it is.
I don't
You know,
like it.
they could
So
do
it-
that at the family law
Yeah,
conference.
so if I don't like the judge today, I'll fill it out. Tomorrow I love her. Fill it out again.
Well, that's
an
just it.
average. That's only fair.
And that's just it, because
That's
people's
not
Are you
feelings.
saying that we're fickle as attorneys? No, come on now.
You
But
know,
that, again,
I'll-
that's only fair.
Yeah. Yeah, go ahead.
Thank you. I've already approached the state bar president about this issue before these survey results came out, and asked if there was an appetite at the bar to look at a more reasonable way of evaluating judges. Because what we really need is sort of a citizens panel with lawyers, judges, maybe even a member of the press on there. People from the people from the community, and I mean, leaders of the community on there, to evaluate the fitness of the judge to run for re-election, or the fitness of lawyers to run for election. And the president said, you know what, we would be open to talking about that. And this gets it out of the hands of the press. It gets it out of the hands of anonymous lawyers who are not interested in being honest, or who have agendas which are hidden from us, or maybe not hidden if you really look at the survey results. And the press, you know, when they write about the survey, they say, oh, this was sent to 1,600 lawyers, but only 101 lawyers answered my survey. So is my career going to hang on 101 lawyers who I know for a fact, some of whom have actually targeted me? Because there's a group who have committed in the RJ that, yes, we've targeted Judge Nathan since she first took the bench. So, you know, should the voters hang their hats on my judicial survey of 101 lawyers, some or maybe many of whom have targeted me? I don't think that's fair. And I think that if the community wants to have a reflection of judges' fitness or a lawyer's fitness to serve as a judge, then it should be done by people who are able to make those evaluations in a very fair and reasoned manner.
Lisa.
I would agree with that. Okay, the surveys. If what Gayle has said is right, because I always say about 50% of the people that appear in front of judges are improper person. But I think you said 61%. Okay, so
We've heard 60% all day.
Let's go with 60%. With that, you've left out a whole base of people who've interacted with that court, and you don't get their opinion anywhere. And just like you said, to have a survey as you go out the door really may not be such a bad idea.
So it tabulates. You add up.
But as far as the
happy, half will be unhappy.
But if they come into court,
well, there's going
so
to be a trend.
if the lawyer come into your court 100 times this year, they get it to go 100 hard, and it's only fair. The
But
emotional changes. You know?
Well, the thing is, and as Gayle pointed out, this is run by one entity. It's run by the RJ. And I can tell you over the years, I mean, first the Bar Association was on board with it, then the Bar Association wasn't on board with it, and now apparently they're back on board with it, and nothing's changed. They're not scientifically accurate. And you mentioned it, I mean, she just said about 101 people. I think mine was like 80 something. It was so long ago. And I agree. I mean, your career can't hang on what this small amount of people say. And I have a problem, although it's kind of different from what Maria said, that attorneys are afraid to fill it out if they have something negative to say. And they don't want to be tracked by cases. But I'm not sure how we really verify that the attorneys, it says you have to have appeared in front of this judge. And I don't know how you really verify that. Does that mean they've seen them, they were in there for a minute, they did an uncontested divorce, or they've been in there for, 20 times? So I think that there's a certain amount of vagueness to it.
Unless you're clerk.
I mean, your idea is a good one. Of course, again, the RJ is not going to do that, but
Of course they don't.
no, they're not going to do that. But the way it stands, I'm not sure how much you can really
not
rely.
fair.
I mean, I would
That's
agree
not
with
fair.
that. And I will say this for the record, because I just want to be clear, because I know that she just said that people are targeting her. I have never, ever filled out an RJ survey in all these years, because I don't think that they're that fair.
And, the point also has to be made that they're not random. When we look at statistics, we look at it being random in order for it to be valid, right? They're not random. So people, as you just heard, called in to gain access codes to participate in the survey. And that was happening all throughout the bar. People were like, oh, did you get your survey? No, I didn't get my survey. Oh, you can call in and get your access code. And so people who wanted to participate because they really wanted to have something to say were getting their access codes. So if it's not random, how can it really be valid?
Well, that's what I said.
That's my thing. It wasn't random.
It's not scientific.
That's just what they are. Polls are only polls.
Well, we are actually at technically we're at 31 minutes, but we had to wait a minute for the film change. So we're exactly at 30 minutes. A neat dynamic with two people who have been evaluated with that question. We had some very interesting, again, some spirited conversation at the panel immediately preceding you guys, which is why they went on over by a little bit. But interesting dynamic. That having been said, thank you again for coming down here. We know it's a busy time of year. You're going to have a lot of fun between now and June 10th. Well, the evening of June 9th. You're not going to be sleeping a lot. You're going to a lot of these events. But again, thank you for coming to ours today.